intelligence in arbitral proceedings, giving rise to, and some common threats that artificial intelligence and other tools present for the security and international contracts. So, of course, the scope is artificial intelligence in arbitration, but also we may deal with other aspects. And to start with, as lawyers, we normally like definitions and to talk about the functionality. If we don't have a definition of artificial intelligence, I believe we will be in a trouble. So it seems to me appropriate to agree some parameters for our discussion. And to start, I would like to ask Giulia, what do we mean by artificial intelligence and how we define it?
Thank you, Orlando. Before answering your question, let me thank the Universidad Panamericana and Professor Edgardo Muñoz and all the esteemed colleagues that are here, which is a pleasure to meet. It's a true privilege to be hosted in this amazing place and city. So thank you, everyone. And it's also good to see again you, Orlando, after I have to say it's more than 2 years. It's actually 6 years since our LLM ended, unfortunately. But let's feel and behave as if it were just 2 years. So, okay, now coming to your question, and allow me to do a brief historical introduction. I don't know if you can see. Okay, you already saw this slide, but historically wise, the term artificial intelligence was coined, surprisingly or not, in 1955 by Stanford Emeritus Professor John McCarthy, which you can see in this picture here. I thought it would be interesting to see how he used to work. He's in his Stanford laboratory with a laptop that I think nobody now uses or have the chance to see anywhere. Professor McCarthy, besides coining the term artificial intelligence, also gave a definition of artificial intelligence. And according to him, artificial intelligence was or is the science and engineering of making intelligent machines. Of course, what he had in mind was something perhaps different from the concept of artificial intelligence that we now may have. And as this is true, the Council of Europe very recently affirmed that nowadays there is no shared definition of artificial intelligence. So perhaps the definition that Professor McCarthy gave in 1955 is not up to date anymore, and we need to search for something else. So actually, I'm not, as you heard also, and as you imagine, I'm not an IT specialist or an informatical engineer, but I try to study it and for the purposes of this presentation, and I found out that at Stanford University there is a center which is called Human-Centered Artificial Intelligence, and they study artificial intelligence, and they try to give a definition of artificial intelligence, which I thought it could be interesting to share with you. And they define artificial intelligence as machines that can learn at least somewhat like human beings do. A second definition that we can take for our purposes, at least today, is a definition given by the Cambridge English Dictionary, according to which artificial intelligence is the use or study of computer systems or machines that have some of the qualities that the human brain has.
Thank you, Giulia. I mean, this is great, and I believe you are correct when saying that perhaps Professor McCarthy's definition is not up to date, because now we have different types of artificial intelligence. So perhaps now you can discuss about the different types, like rule systems, machine learning, deep learning, and generative AI in the form of large language models.
Yes, thank you for giving me the opportunity to talk about these differences, because once again, I had to inform myself and study, and I discovered a lot of things. First of all, I discovered that there is a bit of confusion in the terms that are used in connection with the term artificial intelligence, even among experts. So I'll try to shed some light on these terms, but forgive me from the beginning if I will bring some confusion instead of some lights, because, as I said, I'm not an expert. So I will try to explain what I got from my researches. So the first term which needs to be understood is machine learning. So machine learning is a subfield of artificial intelligence that gives computers the ability to learn without explicitly being programmed to do that. In other terms, as far as I understood, if once computers were programmed to act in a way, nowadays with artificial intelligence, we rely, or we aim at relying on computers that do their job without being programmed to do that. They learn by themselves what they have to do on the basis of information that they are provided with.
And I guess that's the way that Google Translate works, correct? And perhaps the spam of the email, it learns with the massive amount of data and documents from the European Union in different languages, and it learns, so it processes the information and extracts an algorithm, and then it starts translating. I believe that's the way that these things work, correct?
Yes, yes, that's what I understood as well. Yes. Then a second term, deep learning. This is something even more detailed. By deep learning we mean the use of large multi-layer artificial neural networks, which can process extensive amounts of information. I think the example that is given in the slide help us understanding what we mean here. So, for example, in an image recognition system, some layers of the neural network might detect individual features of a face, like a nose or eyes or the mouth, while another layer would be able to tell whether those features appear in a way that indicates a face. And deep learning is currently the most successful machine learning approach that can be used for any kind of machine learning. Then the third kind of term that is used in connection with artificial intelligence, which is the one that perhaps everybody has heard about, is generative artificial intelligence. This can simply be explained as a system that autonomously generate text, images, or video or music, answering to requests that are called prompts. And I think my colleague Luisa will share with you something about this as well later on. Then I would like to make a distinction between what is called strong artificial intelligence and weak or moderate artificial intelligence, whereby strong artificial intelligence is something that I would call pure science fiction, and we would come back to that later at the end of this presentation. While weak or moderate artificial intelligence is something that we all know and use probably every day. They are systems which, for example, make voice recognition or facial recognition, or again, that translate documents from one language to the other in an automatic way.
Great, thank you. So, well, weak, it's something real, and the strong AI, or generally AI, it's something of science fiction, and I believe the movie of Terminator has something to do, Skynet, with that general strong artificial intelligence that today doesn't exist. And moving to other discussion, do we need to adapt a technical definition, or should we instead anchor our understanding of artificial intelligence on what these systems can and will do?
Well, this question is very interesting because, as you said at the beginning, we are lawyers and we like to work with definitions, and I completely share this view. Some key points I would like to share with you. I believe there are some pros, and at least one pro and one con of adopting a definition of artificial intelligence. The pro being that if we need to regulate the use of artificial intelligence in all the fields in which it can be applied, for example, in our case, in arbitration, we need to have a definition. Otherwise, it would kind of being impossible to regulate something that is not defined, because without a definition, you would encounter fears of those that do not want to regulate something that is not defined. The main con is that there is a risk that the legislator goes slower than the technicians, and so that artificial intelligence systems or methods are developed which may not fall under the definition that the legislator created maybe a day before.
So perhaps, if I understand correctly, we will need like a broad definition that could encompass all types of generative AI, deep learning, machine learning, and in the future, who knows what the scientists and business people will invent. So I think that's the best approach, if I understand correctly.
Yes, I totally believe that this is the way forward. And I also saw that in the Silicon Valley guidelines that you circulated, this approach has been kind of suggested or adopted. And I believe that's the way forward. And perhaps a technician should be involved in doing this definition, because I believe we need some. Maybe we as lawyers need some help from another part of the world.
Perfect. And I believe that you somehow explained how artificial intelligence works, but I don't know if you have any other additional comments or thoughts on that.
I just wanted to mention that the problem of the definition, while analyzing this problem, it came to my mind a kind of similar problem that the Italian legislator was facing when it had to define, or when it had to list the substances that were considered as illegal drugs. So the problem was that the legislator was creating a list of illegal drugs, but then the drug makers were adding substances, and so making different substances that do not fall within the list anymore. And this, in other words, the drugs creators, makers, cookers were acting faster than the Italian legislator, and then the Italian legislator decided to delegate the task of listing the substances to the government that acted faster than the legislator itself.
Yeah, I think you draw a very interesting analogy on how we should be careful when tailoring a definition of AI. And now I would like to move to other discussion. Now that we understand somehow how it works, the different types of AI, I would like to ask Luisa, what are some of the limitations of AI technology that may amount to practical problems in its use? And here I would like to refer to a very well-known case that perhaps you have heard, the Mata versus Avianca case, where some lawyers thought it was easy to go and seek the assistance of ChatGPT and ask for help. So these lawyers ask ChatGPT for assistance and for a brief that they were going to submit to the New York courts. They copy-pasted the information, and a couple of days later, the judge asks the Secretary of the Courts of Appeal to confirm whether the case cited by these lawyers existed. And the Secretary of the Courts of Appeal informs that he couldn't find those cases. Then the judge moves to ask to these lawyers if they can provide the source or way where they have gotten these cases. And they have to disclose that they asked ChatGPT for assistance, and ChatGPT invented those cases. So I believe that there are some practical problems, and with this case, I mean, this is the most most concerning one. So I don't know if you can help us to discuss some problems that you find, Lisa.
Hello. Hello. Gracias. Thank you. And before I answer your question, I would also like to thank Edgardo Muñoz y la Universidad Panamericana también por la invitación y por la organización impresionante de este evento. De verdad es un placer estar aquí con tanta gente tan calificada, tan inteligente. He aprendido mucho para estar aquí y he aprendido mucho esta mañana y espero no cansarlos mucho. And switching back to English, and to your question, Orlando, thank you, Giulia, so much for making my life easier, given all of those hard concepts. And now I can get to maybe more practical scenarios. So when we talk about limitations, there's ways that we can look at this. Of course, every AI-based technology will have limitations of its own concerning programming, but let's focus more on the bigger picture. So we understand now that artificial intelligence, especially when we talk about machine learning technology, will be entirely, or at least at the beginning, when we talk about deep learning, on data. It's always data, regardless of where it comes from. So this dependency also generates a need for, well, quality data and representative data, meaning I can't give you data that is wrong or incorrect if I'm expecting proper results, or I can give you data that is biased, let's say. It can also lead to other problems in practice. The dependency that artificial intelligence technology has on data can lead to, I'll deal here with basically two main consequences that I think, one is on the ethical side, so regarding the ethical application of artificial intelligence, and the other one is reliability. So if we understand that people are behind these machines or behind these technologies, we remember every person has biases. And there are people training these machines or these technologies, these tools, these models. And there's a risk that depending on how those people feed these mechanisms, that the data that will be there will also be biased. And the results of the application of the AI technology will perhaps reinforce general stereotypes that we do not want to perpetrate, or will even lead in practice to results, or let's say if in a market, this is in use, if the technology is being used to make decisions, will lead to unfair decisions, sometimes illegal decisions that will be discriminatory. And that will be a big problem. Sorry.
Yeah, and I guess what you're describing is the problem that technicians call garbage in, garbage out. If you give to the machine data that it's full of our biases, for instance, racist comments, or let's assume for a moment that in investment arbitration does exist a bias in favor of investors, then the most likely result is that the machine will keep that bias and keep deciding in favor of investors. But I mean, there have been some examples at Emerson that they started to sort out CVs of people, and it happened that the machine, the algorithm, started to produce resumes or CVs of white male, because the information was biased. So I think what you're describing, it's a concerning problem that we should be aware of when using this technology.
Yeah, and thank you for reminding me of that expression, garbage in and garbage out. I learned it from a very distinguished professor, Professor Joshua Karton, and he's sitting right next to us. But talking about the practical application on how this can lead to unfair, illegal scenarios. So recruiting would be one of them, but there have been some countries in Asia that have started using AI technology to predict whether an individual would commit a crime again. So to determine, to do sentencing and all these things. And sometimes legal systems are already structurally biased. So you don't want to perpetrate that. There is a pattern on people who are convicted. There's a pattern of people who had been involved in his activities. So this will profile some people unfairly. And credit scoring is also a very common one. There's objective data that you inform to the bank or to whatever loan agency that you want, and they'll give you a result. You're either approved or you're not. And sometimes, say, women historically have had lower income than men. So that can be a factor if parties do not watch out for possible biases. This could be a factor that would unfairly prejudice women. And there's also the risk that wrong data or careless training of data will lead to offensive results and prompts. There is this case that was famous from 2016. It's not a legal case, but it's a factual case. Microsoft developed this chat box. There was an AI-based chat box called ltaly, which is called Thinking About You, Artificial Intelligence. It was supposed to replicate the pattern of actions of a teenage girl. So it's supposed to be very spicy and funny and make jokes about things. And they put it up, and within a few hours, there were so many offensive tweets that were racist, homophobic, sexist, and very problematic, and they had to take it down in a few hours. The way that this data was trained was certainly biased in a bad way, and the results showed.
Because it was fitting with all the information from Twitter. Well, at that time it was.
Yes, it was based on Twitter. Yeah, they developed this application within Twitter. So it was sort of an extension that they added, or I don't know exactly how the technology played out, but it was within the Twitter platform that they created this chat box. And so to mitigate, just create, I'm just saying that's very unfair because I don't think it's easy, but there are ways to develop bias detection techniques from the moment that you collect the data, that you try to make sure that that is not biased data. And also once you have this model developed, look at it, test it, evaluate it, and then you decide if you're going to put it up in a market. And in the reliability issue, we'll go back to what Orlando was saying, especially for natural language processing and generative tech. And I like to point out at this moment that generative tech is exactly what made this image that you're seeing in the slide. So I asked ChatGPT, specifically the extension called ltaly, to picture the hallucination issues in artificial intelligence. You see, there's a lot of ghosts in the picture. It's very catchy, and that's what it comes. You see that most of the pictures that I used in the slides were generated by artificial intelligence based on the description of the slides that you're seeing.
So we're safe of any copyright infringement, right?
Pardon me?
We are safe of any copyright infringement.
Absolutely.
Oh,
yeah. I don't think artificial intelligence would claim. Can they claim intellectual property? Oh, wait, that's another discussion. We're not going to get there, but that's exactly what Orlando said. And going back to the case, I'm going to go quickly on this. So Orlando already told you about this case that ended up in the New York Times. So if you don't want to end up in the New York Times, please check your facts, even if you use artificial intelligence. I think the law firm and the lawyers were fined $5,000.
Yes, which was short, I guess.
Yeah. And the institute from Stanford that Giulia introduced to you, so the Institute for Human-Centered Artificial Intelligence, also published a study recently, last month, on the application of artificial intelligence, especially generative technology, to legal queries, to legal prompts. And what they found is that the hallucination rates in this kind of queries rate from 69% to 88% in state-of-the-art language models. So I would say tools that are being used by fancy law firms and even, well, regular lawyers like me that want to have a good time on ChatGPT every now and then. There are several reasons to that, and they point out basically 5 points. So LLMs, which are not, it does not stand for Masters of Laws. It stands for large language models, as Giulia explained. They will fail more often at complex legal queries. They will also be less reliable when it comes to lower court related queries, probably because there's more readily available or widely available on the internet case law or precedents from other courts. In their study, they mentioned that this could also be problematic in the sense of access to justice. So if we're not finding, if ChatGPT isn't finding lower court decisions, who is? And LLMs perform better with well-known Supreme Court cases, another evidence of that. And they also perform better with cases that are not that old or not that new, because if they're too old, nobody's talking about them anymore. And if they're too new, there's too little that has been said about them. And they may also display contrafactual bias. So if there are false premises out there and somebody said something that isn't true or fake news, they may also contemplate that in their analysis. They won't be able to tell the truth most of the times.
And Luisa, what I interpret from the legal study that you are citing is that this is good news for law students, because it means that artificial intelligence will take many jobs, but at least for lawyers, I would not say that we are sitting on safe ground, but there are years, perhaps decades, that we will be using our brains to prepare briefs, cases, and help our clients or as a judge to decide cases. So I think this is good news for lawyers, but who knows if technology will evolve and transform into something more impressive.
Absolutely, we get to keep our jobs a little longer. So there are ways to mitigate. Again, you can't completely eliminate the risk of hallucinations at this point, but you can through prompt engineering, which is also I learned from one of your texts, which is basically thinking about how you structure the prompt. Don't just ask something. Think about how you're going to ask it and how. And with time, as you're using these tools, you're going to learn how to design better prompts. So with time, the level of hallucinations will probably get lower. And retrieval augmented generation, which means basically you feed more sources as you send a prompt. So you send a prompt, but you also give the resources that you want the AI base to look at and consider when giving you an answering. So if I want to answer about the law solely based on 1 or 2, 3 cases, then I will feed that to the system and you will know exactly where to look. And then there's the transparency issue, which sometimes it's not an issue, but in deep learning or deep neural tech, there may be a lack of explainability or interpretability, which means how do we answer, or how do we get answers from an AI chat box, and how did you get to these results? Most of the time, they will not be self-aware and they will not be able to explain how they arrived at a decision. And in certain sectors or in certain industries or in certain jurisdictions, you may be required to explain how you made a decision, why you denied someone of a loan, or why you decided to follow a specific treatment based on a specific diagnosis, why you decided to give to sentence somebody to X years in prison or not another penalty. So for these cases, if the people who are in these positions working in the sectors, they have basically 2 choices. They either go in with all of that they have and suffer and incur in legal and reputational risks, because they may arrive at wrong decisions because of these black issues, and they may not be able to explain and then even suffer fines or other kinds of penalties, or without eliminating that risk completely, they try to develop explainable AI techniques. And then we will need to talk to the people that Giulia said that we needed to reach out to, which are the tech people, and they will help us with that.
And just going back to the black box problem, I mean, I think for the law, this is relevant because decisions have to be reasoned. The judge, the court, they need to give a reasoning how they move from A to B and conclude at C. But for arbitration, I mean, there is a chance that an arbitrator can issue an award without reasons. So there is a small space for the AI technology to move there without any reasoning in the award. I guess that's.
Yeah. I mean, in blockchain arbitration, that's exactly, I mean, what happens in some way. We have like even coming here from Mexico. I mean, I didn't really look at this for this presentation, but I know the Claros case was exactly that. But the parties in that case, even though they chose to submit to an artificial intelligence arbitrator, it was mostly a blockchain arbitration. So it was if-then algorithm. Even though that was the case that they chose, they also appointed a sole arbitrator to basically certify that award. And then there's the discussion there, would that be enforceable? Is that enough reasoning or anything? I will conclude it for now, just saying every AI-based tool will have some tech limitations of its own. If it is just a tech limitation, sometimes you're able to fine-tune, buy extensions, and have fun in the internet.
Yeah, and I believe Professor Karton wanted to add something.
Thanks, Orlando, and thanks to all of you. Luckily for me, it's not my first time in Mexico, but it is my first time in Guadalajara. I'm grateful for the invitation. I'm very glad to be here. Now, I've now been through, I think this is the 5th or 6th panel at an arbitration conference that I've either been at or watched. And it seems that, no insult to Luisa, that people always like to bring some sort of AI-generated materials to be part of their presentation. So I decided to go to the opposite direction and handwrite my notes. It's now working against me because my handwriting is not very good, and now I can't read my notes very clearly because, of course, like all of you, I'm more used to typing either with 2 thumbs or with 10 fingers. What I wanted to say at this point is just to give a little bit more of a context about how AI, and in particular generative AI and large language models work, which kind of explains all of the phenomena that Luisa were just describing to us. And the description that I've read that was the most helpful to me is this. The reason that AI comes up with responses that to us seem like hallucinations, seem fake, is because it doesn't work the same way that the human brain works. We work in intuitive jumps, which is exactly why it is so difficult to write clearly, because we have to take ideas that came to us in a flash and explain them step by step using words, right? That very far from perfect means of communication, but the only means we have, because we can't connect our minds directly to each other. AI, by contrast, does not work in jumps. It works statistically, right? Fundamentally, it is a statistical engine, which means that it doesn't know anything about importance or value. What it knows is prominence, sort of notability, availability, as it's sometimes described. So the hallucinations are because each word at a time, and this isn't specifically how models like ChatGPT work, each word, it measures statistically what is the most likely next word to appear, right? It doesn't even know what a phrase is, let alone a concept, right? It builds word by word, not like our brains do, idea by idea that are then translated into words, right? So this is how you can get a response that is accurate in a way, but totally misses the point, right? Because the AI can't understand the difference in importance, only in prominence. It doesn't know that a Supreme Court decision and its decision at first instance in a trial court have different significance. All it knows is that more people discuss the Supreme Court decision, right, than discuss the trial court decision, right? It can't understand an argument that, even if you ultimately might disagree with it, that's a reasonable argument that is worthy to be engaged with, right? That's not something that fits within the programming of a large language model. Either it is an argument that has been made or it isn't, right? That's all it knows. So to the extent that our jobs are safe, and I would say in some ways they are, and in some ways they aren't, because in actually a lot of what lawyers do is statistical in a way. So for example, contract drafting, it would be very rare for a lawyer to start with a blank screen or blank piece of paper and write a contract from first word to last word. We all work from existing models, right? Using standard terms, using precedent contracts, maybe from our firm or in the same industry. And understanding which clauses go together with which is a pattern matching activity, right? And that is something that AI currently cannot do very effectively, but I suspect within the next few years, not decades, it will be able to do. Where there's a more fundamental difference is in the quality of empathy. You know, when I use the word empathy, people think I'm getting very soft and squishy, right? I don't mean empathy in the sense of feeling sympathetic for someone else's bad situation. I mean empathy in the sense of being able to understand things from more than one perspective, to mentally put yourself in someone else's position, to understand why they might want what they want, or why they might be arguing what they are arguing. That is something that I'd suggest can only occur with the existing technology if the programmer kind of puts a thumb on the scale, just like adds a little loop to the routine to say, Supreme Court decisions are more important. Recent decisions are more important than older decisions, you know, something like that, more relevant. So there either has to be a human putting their thumb on the scale now, or there has to be a different basis for the technology for the AI to be able to do the kinds of tasks that lawyers, not always, but often engage in.
Thank you very much. And I believe you underscore the importance of being aware and raising awareness that artificial intelligence, and especially large language models, work statistically. And of course, they were programmed to provide a logical decision, a logical statement that sounds right, but it is not, or maybe not. And to the second point, Allen & Overy, a British international firm, developed Harvey. Harvey is a sort of chatbot that was fed with all the contracts that this firm has around the world, with offices in Hong Kong, London. And Harvey is supposed to give Allen & Overy an advantage over all other firms, because they will tailor a contract, a clause that is uniquely useful to your case. So this is something that, at least in the arbitration contentious side, we should not care that much, but at least it's a reality, as you pointed out, for contract drafting, at least with Allen & Overy. And moving to the discussion to the impact of parties' use of AI on arbitration and due process, to understand how we as a community can or should address potential ramifications of the use of AI on the integrity of the process, the first step is to understand these ramifications. So going back to Luisa, can you tell us what is the impact of the use of AI by parties in terms of ethics and due process?
Yes. So I would just like to clarify that I'll focus on, first I'll distinguish, our friend here tried really hard to define AI. Orlando has been trying to define AI too. We've all been trying to define AI. Artificial intelligence, for as hard as it is to define, is the broader field. So when we speak about artificial intelligence, we're talking about this broader field of knowledge, the body of knowledge. Some people may refer specifically to the machines that can operate like a human brain would, but it is a broad concept. And then there are AI-powered tools, which are tools that are destined for the practical application of specific AI technology. So specific systems, say the most popular one, I think, for our generation would be, our generation of the last year and a half would be ChatGPT. But in the legal industry, and specifically in the arbitration field, how have we been using, we counsel, speaking, I'm a lawyer, I'm a counsel, I represent parties. How have we been using technology in general? So since the early 2000s, before that, there were already personal computers, but since the early 2000s, a lot of new technology has been introduced in our practice, gradually bringing more efficiency to our practice. Sometimes they may be expensive, but they will make you bill less hours. So firms do tend to invest. So from those foundational technologies, I left some on the screen for you to see. I'm not going to get into the specifics, but then there was this second era that we moved forward, and we started to use also case management and data analysis technologies. And in the latest years, we've been using a lot of large language models technology and other emerging generative AI tools such as ChatGPT, which I came to be very fond of after downloading it and upgrading to the premium version, especially. But there are tools that have been specifically designed to help lawyers. And there are tools that have been designed from existing models such as ChatGPT. So ChatGPT can be the base model for several other tools, including the ltaly tool that I told you that generated the cool slides, the cool images in the previous slides that I showed you. So it's specifically in the arbitration field, going even more specific, not even in the legal field, we already have legal techs that have developed tools that are intended to turn the practice of arbitration, especially the life of the counselor, easier. So both Arbitrator Intelligence and Jus Mundi have developed tools that tend to look at the profile and previous decisions of arbitrators and also arbitral awards, which are submitted under confidentiality usually, if they're not public. And they will issue reports and try to predict whether an arbitrator is less or more likely to grant certain kind of evidence production, or if they're less or more likely to bifurcate the proceedings and try to make all these guesses. There are also other tools like Conflict Checker, which is what you see on the screen now. You can add the names of as many people or registered arbitrators that you know or counsel that have profiles on Jus Mundi and see how they're conflicted, whether they have worked before together in the past. And Jus Mundi now has Jus AI, which is a specific GPT-powered tool that is intended to summarize cases and other arbitrated decisions to make life of the counsel easier as well. But with all of these easiness and facilitators also comes a lot of responsibility. And I'll go back to that now. But we as lawyers, we have responsibilities towards our clients. I dare to say that virtually in every jurisdiction, lawyers will hold ethical and obligations. So we have to be careful with those. We have to do the best for our clients and make sure that we're doing our job right. So as technology develops and some tools are doing research for lawyers, we still have to do the kind of our job that we still have in fact check. So even though in the case that ended up in the Avianca case that ended up in the New York Times, the court, even though it recognized that using AI technology wouldn't be inherently improper, it said that the lawyers themselves abandoned their responsibility by not doing what was there. And with witness statement, and I use artificial intelligence to help me statements. I will do a witness interview, and then I'll have an AI tool, which speech to text technology that will transform that interview into text. Language processing technology to transform my notes from that interview into a witness statement, or even the recording of the interview itself. And again, as a lawyer, we should make sure what they're signing, and it's not that the robot is speaking, and then that's still truth. This is a robot, the judge taking the robot's oath. That's not going to happen in real life, for now at least. So for collection, selection, and analysis of evidence, but we should also make sure that we are looking at evidence and at least that we are dedicating enough time to training the AI tools that we are using to analyze and select evidence. Spend a lot of time there to make sure we don't miss anything that is important. I understand that especially in the arbitration field, I personally work in a lot of infrastructure related disputes that have a lot of technical data, Excels, and also data that has been created by artificial intelligence. So when you get energy, that data, you're interpreting how much energy a certain wind farm produced, or how fast they would do, how is the power curve, all of that. That is created by artificial intelligence, and we can use other tools to interpret that. But again, we need to be responsible in the training part. And just a brief comment here on the integrity of evidence part, and this goes more to the ethical side. A colleague of mine called Leonardo McMurtry recently published on the Kluwer arbitration blog an article on the deep fake defense and how that could be become a trust issue in international arbitration. A couple of years ago, the Chartered Institute of Arbitrators even produced this report on the use of technology in arbitration that was following the boom of the virtual hearings. At that time, deep fakes weren't even a concern, and we're talking about 2 years ago. And now we have, just this week, I might say something wrong here because I saw this on the way here, but apparently an employee from a Brazilian company last week had a meeting with 15 employees from a related company, that this company had businesses in a lot of different countries. And there were 15 attendees in the meeting, and only one of them was a real person. And the 15 deep fakes, well, they were real people, but the deep fake technology in their faces made the one real person believe that they were talking to their business partner, their colleagues. And that person transferred millions of reals to a Hong Kong account. Well, I don't know what's going to happen next, but that's recent. So how can we prevent that from happening in a virtual hearing? How can we make sure that that is a real person? There are ways, apparently. There's ways to watermark evidence. There's, you can create a specific audio video technology that will prevent deepfake. So we would need a specific software. You probably can't rely on a neutral software that anybody wants, or regular Teams or Zoom, but that's a risk. And on the due process part, and here I have more questions than answers. Frequently, when we would ask that question, or you do that research, due process and artificial intelligence, what frequently comes up is the inequality of arms system. Orlando just mentioned that Allen and Overy partnered with Harvey, and it's funny because I brought exactly that article here. Allen and Overy now has access to this super advanced tech chat box that is the chat box of the artificial intelligence. Harvey is kind of a co-counsel, similar apparently, for drafting contracts the other firms don't have. And if you're in an adversarial field, how does that play out? So is the fact that one firm may have access to more advanced, more expensive tools that will bring efficiency and maybe even help them present their case, something that will really mean that there is an inequality of arms, or that they are having their right to equal treatment violated? I would say equal treatment is, my impression is at least if it's not something that the tribunal is doing, that probably could not. There are ways that the tribunal could try to level the playing field. I think in a business-to-business context, this is a hard argument to make, the inequality of arms. Perhaps if we're talking about a consumer arbitration, that could be something for some jurisdictions. Brazil is very consumer protective. First, they would not allow the arbitration to happen, but if it did happen, that probably would be not enforceable, especially if it was proved that they couldn't defend themselves properly. And so yeah, there are ways that people thinking about it. I think I will stop for now.
Yeah, thank you very much. And I believe I want to raise awareness of two issues. The first one, we said that for lawyers, the job is not over. However, for young associates, for young lawyers, and especially this audience is composed of students, I believe you should raise awareness that the type of activities that you would be performing at a law firm or at a courthouse can now be performed by AI. For instance, Jusmundi you can ask Jusmundi to summarize a decision. That's a typical matter for a junior associate, for a young lawyer. And I'm wondering now that we have so many students, how they are planning to address the future, because it's going to be much more challenging than the one we encountered 20, 15 years ago when we started working at law firms or even in the academia. So now I want to move to Professor Josh Karton. What about the use of AI to predict outcomes or appoint arbitrators? Does this kind of private use give rise to a potential impact on the process as well?
I mean, what I would say first is that in general, I think use of AI by parties doesn't create systemic problems so much as it creates risks for those parties. I mean, someone who ignores the possibility that AI tools might be helpful is foolish, but someone who relies on AI results without critically assessing them is even more foolish, right? As we saw with these lawyers who were fined in New York. There was another case in British Columbia recently, a similar one. So really what you need is the sense that the AI is a tool, right? Is something that can help. It can be labor saving. It can be knowledge multiplying, but it can't do the work for the person, at least not yet. So predictive uses are one of the most promising areas because in many ways that is highly statistical. Unless you're in a rapidly changing environment, past tendencies are not a perfect deterministic guide, but a good likelihood guide of what is going to happen in the future. So parties are already using, for example, we saw the conflict checker tool that Luisa demonstrated, are already using AI tools to examine published writings of prospective arbitrators and form predictions about how an arbitrator might rule on an issue in the upcoming case where the parties' counsel are considering appointing that arbitrator. Right? So there's those kinds of uses. There are also predictive uses on things like how one might expect assets to be valued, often a very contentious issue in commercial cases, even more so in investor state cases, often where the valuations have to stretch years or even decades into the future, sort of at a discounted cash flow or other present value analysis. Using a force multiplier for statistics like AI engines can be extremely valuable. But, right, and the big caveat or the big but to that is the quality of the data set that the AI is trained on. Whether it is simply a small sample size, let's say because there are relatively few published investor state awards. I mean, there are now several hundred, but that's tiny compared to the number of court judgments that are published in a large country in a given year, let alone the entire world. So any statistician will tell you that trying to make assumptions or generalizations based on a too small sample size, well, garbage in, garbage out, right? Similarly, you might get a sample size that is biased in some way. So for example, if you're trying to appoint an arbitrator for a commercial case, where the vast majority of commercial awards are confidential and are never published, you might rely on that arbitrator's academic writings. Well, maybe what they write for public consumption does not reflect, their true feelings, or maybe they are purposefully vague about what their true opinions are in order to preserve their ability to get arbitral appointments. Certainly, I've seen that with colleagues in academia, that as they get older and they start to get more appointments as an arbitrator, their academic writing becomes less bold and controversial, right? And more hedged and more careful, right? So if you're dealing with a data set that is itself not representative of reality, the predictions the AI makes will not be accurate predictions. One underappreciated area, though, that I want to highlight is the use of AI in pricing and promoting settlements. And this is something that I think really is very promising. I mean, maybe as disputes lawyers, we have a professional interest in, well, not too many settlements, not too quickly in the process, maybe. But it is an area where that kind of statistical thinking can be particularly valuable. So there's a group at my university at Queen's called the Conflict Analytics Lab. It's a collaboration of my law faculty, our business school, and our computer science department. And they've been doing a number of AI predictive tools that thus far are trained on Canadian court decisions. So just to give one example, they have one tool. The director of the lab, his background is in labor and employment law. And one of the big issues in Canadian employment law is how much notice an employee is entitled to before they are terminated from a job. Right? How long in advance do you have to tell the employee? Or alternatively, how much money do you have to give them? Represented as their salary over a certain amount of time. In Canadian law, this is a highly uncertain, very discretionary, very fact-specific issue. It's just the way the law has evolved in Canada. Their predictive engine, more accurate than the overwhelming majority of employment lawyers in Canada. They've proved it at conferences where they've had employment lawyers guess, well, what notice period would the judge order? The engine is more accurate. That's based on a sample, though, of about 15,000 province of Ontario court decisions going back decades, right? So it's a focused sample, but it's a large number sample within that focus. That's the ideal case for predictive AI. And the farther away you get from that kind of data source, the less useful, the more actively misleading the predictions are going to be.
Great, thank you. And I believe it's important for students and young lawyers to understand and learn how they can use artificial intelligence, because that will be their input when they arrive to work to a court or to a law firm. And now I'm going back to Giulia and to discuss about evidence. Can you share your thoughts on the impact of AI on the integrity of evidence? Will tribunals need technical experts to assess evidence? Oh, okay, we have already discussed about this. So now I would like to move to Josh on AI tools intended to be used by arbitrators. Can you share with us some procedural implications of the use of AI by arbitrators? Could you explain what AI tools may be used by arbitrators in the context of their mission, which is the conduct of the procedure and the determination of a dispute on the merits, including making fact and legal findings and drafting portions of the awards?
Thanks, Orlando. So what I said before, that parties are foolish if they rely entirely on AI. Arbitrators are even more foolish if they do that. Partly just for the practical reason that arbitrators are free agents selling their services in an open market, not a fully transparent market, of course, but a free market of sorts. And low quality decisions have a way of tainting one's reputation for the future, as well, of course, of not serving well the parties in the case where the arbitrator makes a poor decision. So we have seen situations, though, and here is where I want to emphasize the idea that AI is a technology, right? And what technology allows us to do, either the things that we could do for ourselves, but faster and easier, or as a kind of force multiplier to allow us to do more things than we could do for ourselves. Well, you could say the same thing about a staff, right? About an assistant. And there have been a number of cases. One prominent example is the UCOS arbitration against Russia, where there have been allegations that the arbitrators outsourced their work to a tribunal secretary, right, or to an assistant. 15 years ago, when I was doing interviews with prominent arbitrators for a book I was writing that came out of my PhD thesis, one of them told me, well, part of the value added that an arbitration specialist can give their client is the knowledge to say, well, such and such an arbitrator, the only reason they were really good is they had this brilliant assistant who was writing their awards for them. But the assistant has now gone on to another job, so I wouldn't appoint that arbitrator anymore, right? That's the kind of knowledge that, it's that kind of human touch, right? And I would say the same for use of AI tools by arbitrators. So there are some things which are relatively low risk. None of them are zero risk, but relatively low risk and useful for arbitrators. One might be the simple summarizing of facts in a fact complex case, right? One of these cases with all the Excel spreadsheets and technical diagrams that Luisa was mentioning, or just a case with millions of pages of documents. When I was a junior associate, in one of the cases I worked on, my job was to supervise a room full of about 30 temporary attorneys who were just doing document review. And even by the time I left that law firm to do my PhD 2 years later, that process had been highly streamlined by the use of agreed search terms to cut down, right, the range of documents, right? And that technology has developed further, of course. So if we're talking about taking information out of, for example, communications between the parties of the kind you see in the Vismut record, and turning that into a reliable chronology, AI tools can do that pretty well, right? They can't tell you which facts are important, but they can tell you what things happened on which dates, assemble them in chronological order in a comprehensive manner. AI tools might be useful in identifying legal sources that have not previously been raised, but that might be relevant. Now, I don't want to get into the debate over jura novit arbiter. I would suggest that anytime an arbitrator finds a source that has not been raised by the parties, at minimum, they have a duty to raise that with the parties and invite comments on it to protect the parties' opportunity to make their case. But AI can dig up sources that would otherwise be obscure or might just be missed. AI can be useful in comparing precedents, right? Another kind of statistical use. If you're in an area of law that is highly fact-specific, you may want to know Well, what is the weight of precedent in previous cases with similar factual profiles? Where exactly have previous arbitral tribunals or courts drawn the line between reasonable and unreasonable conduct, right? Between market value and inflated value. AI can be useful for that. In the actual drafting of awards, a lot of people have a kind of a fear of the blank screen or the blank page and don't know how to get started. I personally have found in some of my academic writing, ChatGPT is very useful just to not feel like you're starting from zero. But I have found that when I use ChatGPT to start me off, the text that's actually produced, none or almost none of it actually finds its way into the final product. And I think that's as it should be. It can give you a leg up, right? But you still have to pull yourself over the wall, do the work yourself. Right, so we have kind of theoretical problems with the improper delegation of an arbitrator's mandate, although I'd suggest that that's not really different than improper delegation to a human assistant, right, an AI assistant. At a sort of level of principle, they are similar. The arbitrator has been chosen for their personal judgment, right? They're not just a body filling a chair. But then there's also all of the practical risks that arise for arbitrators relying either too much on AI or relying on AI for the wrong kinds of help.
And related to that question of relying too much, what about the improper delegation of personal mandate? We understand that an arbitrator is a intuito persona job, but what about an arbitrator delegating his personal mandate to the AI? How can we tap into the benefits of AI while ensuring that AI does not interfere with arbitrators' personal mandate and ultimately the administration of justice?
I mean, I've got to say this part of the issue I'm less concerned about, right? I would say that if an arbitrator relies too much on AI tools, they're a bad arbitrator, but they haven't given up their mandate, right? Just as an arbitrator who, no offense to any of you, relies on a law student to do all of their research for them without checking it, right? That's probably not a wise thing to do. I was in exactly the same position. When I was your age, I also knew nothing. Right? It's just the reality of it, right? Experience, this is a job in which experience really makes a difference. So I don't really see that necessarily as an improper delegation of the mandate. I just see it as low quality arbitration, which should be rewarded with never being appointed again.
Great, thank you. Giulia, what is the possible impact of the use of AI in arbitration on the enforceability of arbitral awards? Do you see any issues?
Yes, I do. I believe to answer your question, two scenarios should be taken into consideration. The first, okay, here we go. The first scenario is the one in which a moderate or weak AI systems is used by the arbitrators. And in that, like, for example, machine document translations or Google searches engines, these are all moderate or weak AI systems, which we talked about at the beginning. And I don't see, frankly speaking, any issue from an enforcement point of view if during the arbitral proceedings, this system has been used. The other scenario is the one which has been mentioned by my colleagues as well, of let's say a use of a heavy AI system during the arbitral proceeding. And the most, I mean, the highest expression of this kind of scenario is the so-called blockchain arbitration that was mentioned before. Meaning the award is not rendered by human being arbitrators, but is rendered by an AI system, an AI machine. So the proceeding is not conducted, held, or anything is done by arbitrators. Arbitrators are completely replaced by an AI system. Allow me to say that as it has also appeared from my colleagues' previous presentation, I do not believe that this is the way forward. I do not believe that this kind of an award can even be called an award. This kind of arbitral proceeding can even be called an arbitral proceeding, because of course there is well, of course or not of course, but anyhow, what I think is that there is an added value from the human being mind that cannot be replaced by an artificial system, but that's a hope, and it may be limited by my vision, and of course my opinion should not limit myself to avoid to study what kind of issues might arise when talking about enforceability of this kind of awards, because as we have heard, this kind of awards already kind of exist. So we should really take into consideration also issues of enforceability. So talking about enforceability, the again, two sub-scenarios, if I may. The domestic enforcement, so an award that is rendered in a place and that is brought to enforcement in that same place. Those kind of issues I will not deal with, but perhaps I think that the idea here is that if the national legislator prohibits an arbitration to be conducted or to be made with the use of strong IA systems, that same legislator would prohibit the enforcement of an award rendered with that system. Second sub-scenario, foreign like enforcement of foreign awards rendered with strong AI systems. So an award that is rendered by AI systems in a given country, which is brought for enforcement to another country. Here, plainly, I believe the 1958 New York Convention comes into play, and so we should answer the question whether an award like the one we have been talking about falls under the meaning of award given by the New York Convention, even before thinking about if this kind of award is blocked by one of the exceptions to the enforcement that the New York Convention in its Article 5.
And Giulia, I guess that there's an additional problem because in some laws, they require an arbitrator to be a person. I recall the French Code of Civil Procedure and I guess the English Arbitration Act. They hold the word person, or somehow you could interpret that arbitrator should be a person. So there are additional problems in other laws.
Yes, yes, that's also an issue that should be considered. But I think there are two different levels. So the national laws asking for like the one that you mentioned, the French law asking for the arbitrators to be persons, should be taken into consideration for sure as probably the law of the seat of the arbitration or the law of the enforcement. But before that, I think you should deal with the international level and address the New York Convention issue. And so to interpret the New York Convention, you should use the Vienna Convention, the law of the treaties, Article 31 to 33. And so Article 31 of the Vienna Convention deals with textual interpretation. So it's suggested to interpret the treaty as the New York Convention, you should just do a plain textual interpretation of the convention. And if that is not enough, if there remains some doubts or the result that you achieve by a textual interpretation is obscure, you turn to Article 32, supplementary means of interpretation, which include the travaux préparatoires or other means of interpretation which are not textual interpretation. So looking at the meaning of the word term award under the New York Convention, it is contained in Article 1, Paragraph 2 and of the New York Convention, and it says the term arbitral award shall include. So this is not exactly a definition, but it's something that we have to take into account in order to decide whether a completely artificially rendered award falls under the meaning of award of the New York Convention. So it says the term arbitral award shall include not only awards made by arbitrators appointed for each case, but also those made by permanent arbitral bodies to which the parties have submitted. So reading this provision, and I do not think that it is even necessary to go and apply Article 32 of the Vienna Convention to interpret this provision, or the convention, the New York Convention entirely, but we just need to use Article 31 of the Vienna Convention to interpret this provision and to conclude that this provision does not include awards made by artificial systems, because it seems to me that it talks about arbitrators, which to my perspective are not cannot be meant to be those artificial systems, or permanent arbitral bodies, which not even are those artificial arbitral systems. So this, coupled with the national legislation provisions that Orlando was mentioning before, brings me to say that there might be great issues in bringing and enforcing a blockchain arbitration award, either abroad or in the same place as they are rendered.
Thank you very much. And now moving to online, Marcos, are you there?
Yes, I'm here.
Thank you very much, Marcos. Should AI be regulated within arbitration, and if so, how? Procedural orders, soft law, arbitration rules. I think, I don't know if you recently heard a podcast where Bill Gates interviewed Sam Altman, the genius who invented ChatGPT, and the president of the company AI that produced ChatGPT, and he said that there was going to be a international code that all nations would adopt, and that's how he envisions that AI would be regulated. But I don't know, what are your views for specifically in an arbitration process?
Thanks, Orlando, and I have to thank Edgardo, Universidad Panamericana, for the invitation. Unfortunately, I wasn't able to travel to Mexico and enjoy the company of the distinguished panelists, and also enjoy the city. The short answer to your question is that the current regulations that have been adopted at the international local level do not refer specifically to the use of artificial intelligence in international arbitration. So the rules we have make reference to use of technology, but that is limited to remote hearings, and that was adopted because of the COVID. So if you ask me whether this should be regulated, I would say yes. But what I think is that that should be at the process level, meaning an obligation of the arbitrator. I was intending to go through what we have, so sort of, but that has been taking place so far. I just like to mention that there are recent regulations and even a recent guideline from the English, the office holders on artificial intelligence for the use of artificial intelligence, that was from December 2023, which helps somehow on the use of the artificial intelligence by arbitrators, although it is intended for justices, that could be used as a guide. But I believe, as said by Josh, that the using of artificial intelligence to render an award is the same thing, and the same discussion that we had when using secretaries or assistants for issuing awards. At the end of the day, it's the responsibility of the arbitrator, and he or she should be the one entrusted with taking the decision. Could be assisted, but they should take the decisions. I was also reviewing the UNCITRAL model law And as you have already said, that law also refers to some principles that must be present in arbitration. So the use of artificial intelligence in a manner that may impact the right of the parties in the process, of course, may have an adverse impact on the process and also on the award. I know there are some other concerns, for example, confidentiality, but that is inherent to arbitration. So there are the rules already refer to that. So that's something that perhaps doesn't need to be specifically regulated. So I think that the regulation of artificial intelligence should be done sooner than later. And as I said at the beginning, that could be achieved not necessarily at the legislative level, but during the process by the arbitrators or by the institutional rules. Of course, some sort of guidance, some sort of soft law could be useful for the arbitrators at the parties at this point.
Great. Thank you very much, Marcos. And to that point, the Silicon Valley Mediation Arbitration Center developed some guidelines, soft law, on the use of artificial intelligence in international arbitration. Time has come.
Before you go to that, he's in the drafting committee of those guidelines.
Yeah, I need to promote that. And also, if you can vote in GAR, is promoting GAR as a new development. So please vote. I'm sorry. I needed to do promotion for the work. But time has come for an end of the panel. However, Edgardo was informing me that we have a good deal of questions. So I don't know, Edgardo, if you want to address those questions.
Yes, I have to announce that this panel has won the competition of more questions, beats the previous panels.
Yeah.
We have several, probably we will not be able to go through all of them. Oh. And probably we will start with this one because we have online people. Okay. This is for Joshua, but I think also could be answered by Giulia. And it reads, if artificial intelligence can reliably predict an arbitrator's decision, can you challenge the arbitrator based on an issue conflict? So if artificial intelligence can reliably predict an arbitrator's decision, can you challenge the arbitrator based on issue conflict?
I guess what I would say is that artificial intelligence technology might help you discover a potential issue conflict, but it cannot make an issue conflict, right? It can't create a basis for a challenge. All it can do perhaps is uncover a pattern in published writings, for example, that might then be argued to constitute an issue conflict. So I'd say it's a tool that could be used in that process, but once again, it can't do the work for the lawyers.
Do you want to add anything, Giulia?
No, I completely agree. I think I see artificial intelligence tools as tools, not as results or results productions. So yeah, no, let's move forward. As I heard, there are a lot of questions. So
Okay, so this one is pretty interesting and is kind of anthropological. Since artificial intelligence can solve simple tasks that now are performed by trainees, what is your forecast on the training of future generations of professionals? Are they going to be less prepared? This is for everyone who dares to answer.
Sorry, Edgardo, you said less what?
Let's prepare.
If I may, I believe that young people, students should arrive to the office, to the courthouse, with an understanding of artificial intelligence and guide the other guys, the other people on how to use it properly or not. I think that would be my advice for young generations. I don't know, Giulia, I see your expression. I don't know.
I think that what this question means is that what our training is gonna do if artificial intelligence will do the tasks that they are usually assigned.
But, well, I guess they should raise awareness on all the hallucinations that, for instance, Luisa told us, that how to train the algorithm, how to properly draft a prompt. The legal industry, I believe, will change substantially within the 10, 20 years. And this is why new lawyers should learn how to use it and arrive to the office with the knowledge limitations, hallucinations of the system. But I don't know, Joshua, you want?
Ladies first.
Thank you. I think regardless of the market situation, whereas you're going to have your job or not, and because it got to open the door for an anthropological point of view, my perspective is that younger practitioners will also miss out on more if they take shortcuts. We were talking about it over lunch, especially talking about the working remotely and how much that affects junior attorneys more than it affects senior attorneys, because they miss out on the opportunity to meet senior practitioners in formal learning. They miss out on so much that they wouldn't miss. And I think using AI to turn whatever text you're performing more efficient may help you, but at the beginning of your career, I would say taking shortcuts might not be the best way.
Yeah, I mean, I think there is a genuine concern here, in the sense that, when I was a junior associate, one of the tasks that I was assigned was creating a chronology of, complex sets of transactions, right? Or assembling a summary of the case law. And the skills that I developed through doing that are essential to working as an arbitrator, right? To understand complex sets of facts and to try to make a conclusion based on them. So there is a risk that if junior associates no longer sort of put in the hours doing those tasks, you won't develop those skills. But, technology gives and technology takes away at the same time. There is evidence that before widespread literacy, humans' memories were much stronger than they are now, right? They have evidence from shopkeepers in the Middle Ages who could keep an inventory of thousands of items in their shop and the different prices and where they were supplied and so on entirely in their memory, right? And when we started widespread writing as a society, our memories got worse, right? But of course, there are compensations. So what AI tools do is they outsource, out of our brains some of the work that we used to do. The risk is that then there is just less work, right? That is a real possibility. But the other possibility is just that we end up doing different work, right? Because different parts are handled by the technology and by ourselves.
Okay. Well, this one reads, people is bias, and unconscious bias is a big issue in decision-making process in humans, right? But people can be trained to avoid how not to be unconsciously biased. Can we train artificial intelligence to do that?
It's okay. I'll give my answer. Yes, there are bias detection techniques. So as I was saying, it's not possible to eliminate it completely. The training data will always, at least at the first part of the process, come from a human person. And I mean, I think this person that wrote that question is very optimistic, saying that we can be trained to avoid bias. I think we become conscious of our own bias and we try to avoid acting on them. And maybe we do become more conscious and change our minds. But with technology, you can develop other artificial intelligence models specialized in detecting biases in results of outputs that were generated by AI. So that's already a possibility. I can't name a specific software, but I know that in certain sectors, people are doing that. And you can train the people behind the machine. You can train them to try to avoid their own biases, and perhaps that would be a better solution. But unfortunately, there's no, at least for now, a 100% solution for the unconscious bias potential.
I mean, the theory would be if you could train an AI on an unbiased data set, something different from the total postings to Twitter, right? The problem is, how do you know whether a data set is unbiased? So far, at least a human has to make that judgment.
And that would be biased.
And they could be biased. They are, but we all are. We just either are aware of it or not, but we're all biased.
Excellent. This one, probably Orlando can add to this one something. How do you think, and the rest as well, but it talks about the specific example in Mexico. How do you think is an appropriate way to fit the artificial intelligence data banks with the legal approved criteria, For example, the Mexican Supreme Court announced last year the development of Julia, yeah, and an artificial intelligence that filters our precedents to help lawyers.
Well, I guess that's a much constrained universe. The problem with ChatGPT is that it had access to all the internet, and you can find garbage in the internet. With Giulia, I was not aware of that, but it's a constrained universe similar to Harvey that was developed by Allen and Overy, that you will have only the present. So technically, the possibility of having hallucinations that our colleagues explained would substantially be diminished. So even if there could be hallucinations, those could be minimum, but also it's relevant to test the technology. Richard Susskind says that we could have an award, a case decided by an algorithm, but we will need to train thousands of times just to be sure the level, the rate of failure, the rate of success. So I think trial and error is also important to be sure that what we are getting as an answer, it's useful for our case, for our daily practice. But I guess it's the same. Using artificial intelligence is like using a junior associate at your firm, at a courthouse, a law clerk. Someone needs to review what it's doing. And that was the problem of Mara versus Avianca. They just copy pasted and forget to review. And that's completely irresponsible. So I guess we humans today, with the limitations we have, we need to review what we get as an output from the algorithm.
Okay, probably I mean, there are others, but probably this should be the last one. And I apologize for those whose questions I did not read. It starts with a comment for the panel. It says, rest assured, artificial intelligence prompts are not copyright claim. Okay, so
Thank you.
I'm
relaxed.
But the
now.
training data might be, right? There are some ongoing lawsuits and threatened lawsuits about that.
Yeah, probably the product, the byproduct, right? And then it says, how should black boxes improve in the future? For everyone.
I think the recommendation, I just told you my friend here, Orlando, is in the draft committee of the Silicon Valley Arbitration Mediation Center draft guidelines on the use of artificial intelligence in arbitrator. They address in the explanatory notes, the introduction part, the black box issue, and in that part, and developing explainable techniques would be one way to mitigate that. But again, I think I touched on this point and then I agreed with Giulia. I'm not sure how lawyers would be able to develop that kind of technology, an explainable AI. But apparently you can't, you can do it. Somehow, I don't know how the technology would be. I would say for the best recommendation to companies who are taking human-centered decisions and using AI is that they avoid using AI to make those decisions. So that would be the most responsible one, to avoid reputational and legal risks, even if an automated decisions ends up being illegal and discriminatory. So the advice for now for sectors that require explainability of their decision making would be avoid that kind of mechanism.
Just one other thing, what I think is probably going to be the most valuable in terms of improving these tools in the future is a repeated collaboration between the users and the makers of the technology. right? So for example, if you conduct all of your settlement negotiations through a portal and the AI has access to the data from that, it's going to be able to make better and better predictions over time as to what a reasonable settlement value is, right? So the projects that currently exist that sort of give me the most optimism are the ones that are collaborations, where the use by lawyers is fed back in to train the next version of the AI tool.
And just one additional comment. We are assuming that the black box problem is a problem because for court decisions, we need a reasoning. We need the judge to say how he reached C from A to B. But perhaps we don't need that. Perhaps the justice, and let's think in the mind of these people like Elon Musk and Jeff Bezos, that they are transforming the economy, that they decide that they need different type of decision making. And if we use Uber, we are already using an algorithm when we have a dispute regarding the credits or the charges that we receive. And it's an algorithm, it's not a human. So we are already using a technology which has the black box problem because we don't get that reasoning on how it reached the decision. And it's not such a big deal. So perhaps the future could be that we don't need a reasoning, and perhaps we can train two different algorithms. And if we like the level of satisfaction, the rate of success of these two different algorithms, perhaps we can use that as a decision making. And perhaps that's business oriented, more efficient, more expedited. And we don't need to have years in court just to decide a case. So some ideas.
Yeah.
Excellent.
And just to, in the Silicon Valley draft committee, and the entire committee apparently agrees with us that this issue would be beyond the reach of non-technical individuals like ourselves, understanding the AI explainable technology, but AI explainable technology would be the only way to avoid the black box problem. How we get there? That's the tech people.
Perfect. Excellent. So I would like to conclude by thanking the moderator and the speakers, also in particular to Marcos Peña, who connect from Dominican Republic. Thank you so much, Marcos. It's a pity we don't have you. And as a token of our gratitude and to express our gratitude, we would like to offer them also a small souvenir from this university with all our heart. Thank you so much. Thank you. Marcos, I should send you this present to you by
Yes.
courier service, or probably you probably plan to come to Guadalajara before I give it to you in person here. Well, thank you so much.
Thank you.
Well, you may go to your seat if you want now, but to conclude with this wonderful journey, but no less important, we kindly ask Professor Lisa Españolo to come here to the podium and to give us the closing message of this conference. Please, Professor Españolo. And the speakers may take their seats in the audience.
So thank you very much. It's been a real honor to be asked to give the closing address to today. And in true moot style, I want to propose to divide my time not equally, but between two issues. The first is to give you some comment on the incredible wealth of knowledge that we've heard about today, and the thoughts and interchange of ideas that we've been privileged to enjoy today. And the other issue is to perhaps give some reflections on the Vismoot, which I know is something that many of you here today are heavily involved with and devoting your lives to at the moment. And I don't think I'll need to reserve 1 minute for rebuttal. So let me start with perhaps the most important thing that I want to do, and that is to sincerely thank the organisers of today's conference. Professor Eduardo Munoz, who I know has a very hardworking team behind him. Your efforts are greatly appreciated, and thank you very much. We've all been in awe of how wonderfully there's been attention to detail, generous hospitality and thoughtfulness, so thank you. And I think I can say there are very few conferences organised as well and run as well as the one that we've experienced today. And I wish to thank the university also for their generosity and meticulous work in putting together a stimulating day of really thoughtful presentations and discussion. Wonderful venue as well. Thank you very much. I also wish to thank all of today's speakers for your enlightening papers. So much work has been put into it, and I think they'll give everybody here a great deal to think about in the months to come. Now, with that, I'll now make a few remarks about what we've heard today, although I'm going to be very brief because I don't pretend to know as much about many of the topics that we've heard about today or to do them the justice that they indeed deserve. First of all, we had the wonderful warm welcome from Dean Alvarez from the Faculty of Law here. Then we had the keynote address by Professor Schwenzer. And of course, it's always an honour to hear from the professor. In this case, we had a masterclass on the very tricky question of the borderline between the CISG and domestic law. When does the CISG apply exclusively, preempting domestic law? And when can the domestic law apply concurrently alongside the CISG? So not only giving us her views about mistake, initial impossibility, tort and procedural matters, but also the principles behind that view, which is so important. When we take those principles, we can then apply them to lots of different things. We then had panel 1, talking about the addition of claims and consolidation in arbitration. So Diana Correa giving us the historical perspective in the ICC rules and the ICDR rules, and how in common we learnt multi-party arbitrations actually really are, and the manner in which the arbitral rules have to keep up with that and have tried to do so. Then we heard from Ilyana Bardin, who clarified very usefully the concepts of joinder and consolidation, and who makes the decision to allow those things to happen or not, across a broad range of centres on arbitration. And indeed, the questions separated out, can we have consolidated matters or should we have them? Renato Treves also provided us with a really useful comparison of the rules from the SCC, the LCIA and the ICC, and UNCITRAL rules, and even ICSID as well. The similarities and differences to how these work in practice, the extent to which tribunals or parties are limited in their ability to bring new claims or amend claims, and the relevant factors that can be used to argue that matters should be consolidated. And then we had Elisa Ortega, who finished the discussion of the good and bad effects of consolidation in terms of cost, efficiency, and the risks of inconsistency or even just poor quality decisions, and also confidentiality. And I think panel 1 really gave us a really good example of why it's so important to listen and value the learning that we get from practical experience. Panel 2 had a very lively discussion. We started with Francesco Mazzotta, who gave us a great outline of the difficulties that the common law has with good faith and the contrast with the American approach and that emphasis on predictability and how far we go in the development of information duties based on good faith, and where common lawyers might be a little bit more uncomfortable with that. Myself on Article 80, of course, and the development of a duty to warn based on information known by one party but not the other, and the risks of losses and breach. And then David Tebble, who talked about and demonstrated information as a basis for liability and also exclusion of liability under various articles in the CISG, but then also developed the view that there might be a general duty to inform in the CISG arising on the basis of looking at specific instances of duties to inform, and then advocating that this extends to a duty to inform to prevent harm to the other party. And then Sophia Young also giving us an intriguing insight on the workings of Spanish football and information duties in that context, in such an emotional and unpredictable and speculative business, which is professional football today. There we find there are some problems from the lack of a duty to inform regarding matters that bear upon the value of players in transfers. We then moved to panel 3 after the wonderful lunch and the break, and then that was, of course, the panel that we've just had on AI and internet security. Giulia Vallar took us through the definition of AI and the pros and cons of defining AI, and then the really interesting question of enforceability of awards. And I think that's going to be a much bigger deal as we get further and further into the reliance upon AI. We had Luisa Quintao, who talked about the problems from the fact that AI produces outcomes that can be affected by bias in the data inputs and the ethical problems for lawyers. And of course, the beautiful and quite scary hallucinations, which include fake cases, which I have seen being produced in student work too. Joshua Karton talked about the way AI works and how that is different to the way humans and lawyers, which can sometimes be the same thing, how they work. So it's we are glad to know that our jobs are safe for now, but who knows? And then we had from Joshua also the need for critical review of outputs of AI rather than blind reliance, and the use of AI tools by arbitrators when it might be appropriate and when it might not be appropriate to delegate responsibility to AI. And then Marcus Rodríguez also giving us the question of regulation of AI and the view that it should be regulated in the context of arbitration in particular, and the extent to which rules can currently contend with current concerns. And we heard the recommendation that there should be guidelines, and perhaps those are actually on the horizon. So great question and answer section followed that panel, and thank you to everybody who contributed their questions there. So we've heard from voices all around the world. I also want to acknowledge the skill of the moderators today, Gabriela Cosia, Ingeborg Spencer, and also Orlando Cabrera, all providing great questions, teasing out the substance of the issues and keeping everyone on time so that we're not here all night. So with that, I've finished with my first issue, and I want to move to my second one, which is a topic very close to my own heart, which is indeed an issue that brings year after year a combination of the worlds of arbitration and the CISG, and that's the Viz moot. In the past year, we sadly lost Professor Bergston, who is often referred to as the father of the moot. But I'm sure the things that I'm about to say would bring a wry smile to his face, because I want to now present an argument to each of you, if it please the tribunal. And my submission is that there is a very close relationship between the Viz moot and the development of the law, both in arbitration and in the CISG, but I'll take the latter as my case study. And I will produce some evidence to support this proposition, but first, I want to start with some general observations about the moot, as many of you are now entering into the Viz moot family for the first time. You might be amused to know a few things. The first thing I want to say is about the topics covered by the Viz moot problem. Very noticeably, early moot problems focused on the questions within the CISG of formation and remedies. Whereas in the past 12 years, the focus has been much less on those things. And quite often, in fact, 5 times, we've had the focus being on the scope of the CISG. How far can we stretch the CISG to still fit problems of today? So one of the areas that often gets the focus of the moot problem is the area of technological change, increased sophistication of goods, and increased complexity of the transactions that we deal with. For example, know-how was one of the subjects of the 2021 moot. Software was also the subject of the 2014 moot. And the question about freedom from child labour as a quality of the goods has also been a subject of the moot. Then we have the goods themselves. Now, for those of us who've been involved with the Viz moot for many years, this is how we refer to each problem that has happened in the moot. We refer to it by the goods that were involved. So we've had the turbines moot, the fuses moot, the cakes moot, suits moot. Indeed, wine has been really popular. That's come up twice, once with added antifreeze. And quite odd goods have been the subject of the moot. One time we had squid, and another time, believe it or not, we've had horse semen. This year, of course, we've got the sensors. The length of the problem and its format have changed drastically over time. Back in the first moot, I know this year's moot, it's 66 pages long, right? Well, in the first moot, the problem was factual only, and it was 4 pages long, 4 whole pages, with no correspondence between the parties being reproduced at all. There was no procedural documentation. There was no pleadings, no terms of reference. You basically just had to guess what you were arguing about. In 1995, the problem was by then 8 pages long, still no correspondence between the parties. In the third moot of 1996, we now had a 13-page long moot with a request for arbitration and a statement of claim, and some extracts from the correspondence between parties as the evidence. 1997, we see something closer to what we see today with correspondence between the parties and 18 pages. And by 2004, we're up to 43 pages in length. Now, some fun facts. In the first moot, the goods that were the subject of the dispute were the rather salaciously known or named Super Sexto computer chips. In the second moot, the moot problem in a note to students hilariously explains that email was a new electronic method of unstructured communication, mostly used for short messages and used by quite a few universities. We've had various countries involved with the moot. One which has disappeared from view these days is a country called Polarity. And there's been a Dr. Viz as a character in the moot. And we all know and love the 2 quite incompetent lawyers that keep popping up year after year now, advocating for their clients. Joseph Longweiler did not appear for the claimant, however, until 2002, whereas Horace Fasttrack, despite his name, only appeared in 2004. Now, the relationship between the development of the law on the CISG and the Viz moot. I want to put it to you that there is a correlation between these 2 things. I can't say that that proves causation, but there's definitely a relationship of some type. Sometimes the moot problem picks up on issues previously discussed by cases and authors, whereas other times it tends to be the other way around. So, for example, in the 10th moot, which was about film products, we were asked 2 important questions on the CISG. The first was, does Article 78 grant the right to claim interest on damages from the time of the breach or only the time of the judgment? And this had been discussed in journals within the years leading up to the moot, particularly in the Vindobona Journal by Christian Thiele, who argued that indeed there was a right to interest from the time of the breach, and it was on the basis of unjust enrichment. However, some 10 years later after the moot, we found that we had the CISG Advisory Council Opinion number 14, which in 2013 agreed that the right to interest would be from the time of the breach, but not on the basis of unjust enrichment, instead on the principle of full compensation. The other question raised in the same year was whether the choice of national law was an implied exclusion of the CISG. Some 2 years later, we had articles in the Vindobona Journal on this question. And of course, CISG Advisory Council Opinion number 16 took this issue up a decade after that moot as well. The 20th moot in 2013 was on polo shirts, and it asked the question, can parties themselves agree to contract out of the national reservations declared by member states of the CISG? In particular, in that case, Article 96 declarations to impose writing requirements on parties. So this question had been raised in case law prior to the moot and in various academic journals. 9 years before by Camilla Anderson, 2 years prior in a case, Forrestal, Gurani and Davros in the US, also by a former mootee, Wei Long, in 2 years beforehand in a collection of publications in a book. And in the same year as the moot, Ulrich Schroeder, himself a former mootee, wrote on this issue. And subsequently, he became the rapporteur for CISG Advisory Council Opinion number 15 on this very point, which was also published in the same year as that moot, 2013. So coincidence? I'm not really sure that's a coincidence. 2014, we had the hospital scanning software moot, which asked the question, is software a good for the purposes of the CISG? Now, this had been a contentious question. It had been debated before the moot in a number of articles, for example, in 2003 by Mowbray and by Hirosono in the Kritzer Festschrift. And they'd argued, no, it's not a tangible good. Whereas in 2003, we had Diedrich and also in the Journal of Business Law, Green and Seidoff arguing, no, in fact, it can be considered a good. CISG does not have a tangibility requirement. So they argued that mass-produced software should be seen as a good. 3 years following the moot, we had another mootee, former mootee Thomas Newman, write and propose a new model of deciding whether software was a good, the dominant control model. We then had in 2016 a highly contentious question in the 23rd moot involving wine. Could lawyers' fees be recovered under Article 74? Now, no doubt this had been inspired by a case, Zapata, which had been a US case decided some 13 years before the moot. We had many authors that were writing on this issue, criticising that case, Joseph Luskowski and Harry Fleckner. They'd been highly criticising the Zapata case, saying that the district court had got it wrong to allow such an award under the CISG. But then Judge Posner made a judgment on reversing that award on appeal, sorry. And they said that Joseph Luskowski and Harry Fleckner said, Judge Posner had reached the right conclusion, but for the wrong reasons. He said it's outside the scope of the CISG, but for the wrong reasons, that his reasoning was that it was because it was a procedural matter. Then we had in 2006, the CISG Advisory Council also just looking at this same issue and deciding in Rule 5 that indeed it was outside the scope of the CISG, this question of recovery of lawyers' fees, but not because it was a procedural issue, but instead for other reasons. So this back and forth between the moot problem and academic writing and case law is very, very evident. I'll give you one more example, I think maybe 1.5 more examples, I'll put it that way. 2017, getting quite recent now, jet engine blades. And the question was, is it the seller's responsibility to know and comply with and bear the costs of complying with public law regulations in regard to Article 35(2). Now, this moot was most probably inspired, of course, by the green-lipped mussels case, the famous German Supreme Court case some 20 years before, and the fact that the same issue had been also the subject of a New Zealand case, the Smallman case, some 6 years before the moot. So those cases probably led up to the moot. But also we find that in the very next year after the moot, 2018, we have a CISG Advisory Council opinion number 19, which clarified the factors that should be taken into account in determining whether or not a seller bears the responsibility for compliance with regulations. Things like relative expertise of the parties, the prior dealings within that country and so forth. So again, quite a close relationship between the timing of the moot and the events leading up to it, but also thereafter. And finally, I just want to mention the 2019 moot because it's the one involving horse semen, but also it had a very interesting legal question, and that is, does Article 79 of the CISG allow adaptation in circumstances of hardship? Now, this moot problem was probably inspired by the Belgian Supreme Court decision, a very controversial decision, the Scaffham case. And that case had held that the word impediment in Article 79 included the concept of hardship, but it also decided that the remedy of adaptation was provided for and made that decision on the basis of the CISG. The following, in 2020, in the same year, we had a number of a number of articles on this question. And in the same year as the moot, or the very next year, we had CISG Advisory Council opinion number 20, which the rapporteur for is here in our front row, Professor Munoz, and that taking up the respondent's alternative argument that indeed CISG Article 79 does include hardship within the term impediment, but taking the position that adaptation is not a remedy available under the CISG. So again, the moot problem highlighting a concern in the area of development of the CISG and responses coming in the wake of the moot problem or alongside the moot problem as those arguments are developed. So I put it to you that correlation is indeed not causation, but that the moot does inspire discussion about the development of the CISG, but likewise discussion and where issues become quite debated in the cases and in the scholarship, that can also inspire moot problems. The two are intertwined. And as I've mentioned, many of the authors who are involved in developing this discussion are themselves former mooties. So what I hope from today is that you've been inspired and that I look forward in the future to reading from many of you writing about the CISG or indeed arbitration, which has a similar relationship with the moot and the development of the law of arbitration. So as this area of law becomes more and more developed, I do look forward to seeing you join that debate as part of the VisMoot family. I wish you all good luck for tomorrow for those of you participating in the pre-moot. And I ask you to once again join me in thanking the organisers of this event for the wonderful experience we've had today. Thank you very much.
Thank you so much, Professor Españolo. I really identify myself in several of the things you mentioned about the mood. I was myself a moody. At some point I feel old, at some points I feel very young because I actually, it's 31 years and I did the 20 edition, I think. So it's a time to conclude, but before that I need to acknowledge several people, a group of people that made this possible. I should start with the speakers. Without the speakers, we wouldn't have the discussions that Professor Españolo just talked us about and that were so insightful. So thank you so much to all of you coming from different countries as far as Australia, like Lisa, our colleagues from Mexico City as well, Italy, United States, Brazil, Canada, Germany, am I missing? Dominican Republic, Spain, Canada, yes, I already said. I think that's it. It's a pretty diverse group of speakers. And also, I think the highlight is that the vast majority of them were lady colleagues, professors, eminent minds in this field. I think that probably 70% or 60% at least. So thank you very much. The second group of people I need to thank is the attendees, the students, most of them at this room, but also some of the practitioners, former Moody's, current Moody's, and of course, all those that tune in the conference from all over the world. We noticed people from Morocco, India. I mean, India was late and they still were there listening to you. Different parts of Europe, Eastern Europe, Brazil, many from Brazil, Peru, obviously Mexico, United States, and a couple from Turkey. So thank you so much as well to contribute to the development of this program over the years. And without your participation also, it wouldn't make sense to do it. I should also continue with the supporting organizations that are just at the bottom of the screen. They help us to disseminate information about this program, this conference, CR, which is Charter Institute of Arbitrators, specifically the Brazilian branch, the CISG Advisory Council, that is this private initiative, academic initiative that was mentioned several times by Professor Españolo at Issues Important Decisions on the CISG, Canaco from Mexico City, which has one of the main arbitration centers, ICC Mexico, of course, one of our main partners for arbitration programs in this university, CAM, the center, the Mexico City Arbitration Center, the Mexican Bar Association, in particular, the chapter from this state, from Jalisco, the Mood Alumni Association that help us to disseminate and yes, spread the word about the program all over the world. And finally, Corredores de Jalisco, which are the commercial brokers. Last but not least, and more important, this event has been prized by being perfectly organized. And the person responsible for this is my colleague, Lupita Ramirez, which is at the back. I want you to have a look at her. She's there. And she's been taking care of the organization of these 3 days, not only today, but tomorrow and after tomorrow for the last probably 7 editions. And to the point that she's the mind and the body behind all of this. The rest of the team, which in the faculty that we work as well in this project, are just helping her because she's got the wheel on everything. So thank you so much, Lupita. We hope we can have you for the next 10 editions. Okay, that would be it. And thank you so much. We hope to count with your participation next year, same week of the year. And Thank you, speakers and attendees.